Okay, the rest of you, camera off one, can please turn on. Because it's easier for me to communicate if your camera is on instead of off, you see. Okay. Can you all hear me clearly? Can? Okay. Okay, just a short intro. My name is Lishani. I'm practicing as well as I'm teaching part-time. I'm practicing in civil, under civil litigation for quite some time, 7 years plus, 6 years plus. So yeah, that's about it. About it. Criminal, I just started criminal. All this while I've been doing civil litigation. So if you have anything about civil, you can ask me civil and evidence. Okay, today we'll be doing order 34 and order 35. Okay, order 34 is your PTCM and order 35 is your trial provision. Okay. I have my own note. I mean, I will be using, I know all of you, I have different notes. I'm not going to use any notes. I'm only going to use your rules of court. So I hope you all have your rules of court with you. Everyone, please. Okay, you see why I don't want to share any notes here is because each one of you will have different notes. Okay, so your notes, the cases will be different from mine. So I don't want to confuse you all. So you just use whatever cases that you have. You don't have to follow my cases. As long the principle is the same, the provision that we are putting is the same, that's fine. All right. So before I go into the questions, I just want to explain briefly on order 34 and order 35. Okay. What you need to know. Okay. What you need to know about order 34 is that, okay, what you need to know about order 34 is that order 34, turn to your statute book, order 34. The first distinction between order 34 and order 35. Simple distinction is that order 34 you can only use for pre-trial case management and order 35 you can only use for trial. So if your question, this one you must be very clear. First thing when you read the question, in order for you to see which provision I should apply, you must first determine what stage of the proceeding is it. Is it during trial stage or PTCM stage? If it is PTCM stage, forget about your order 35. Don't have to look into your order 35. If it's your trial stage, forget about your PTCM stage. So this first thing you have to be very, very clear, because let's say you choose the wrong provision. If the question is talking to you about order 34, but you choose order 35, the whole answer is wrong. So if 12 marks, if you're going to tell me I've answered correctly in the absence of one party, the court can do this thing, okay? But you have choose the wrong provision, 0/12, confirm. Civil is that way, is you know or you don't know. You cannot choose in between, okay? So you must ensure this the first thing you need to know. Order that you need to look at the question. You need to look at the question and see they're asking you about order 34 or order 35. That's the first thing you need to know. Second thing you must understand, for order 34, now, as of now, we are no more using dismissal of case of one of prosecution, although it's still there in your syllabus. Now we are no more using it already. Okay, what we are using is only order 34. Let's say someone don't comply with the pre-trial direction. What can the court do? Everything is governed under order 34. Okay, you don't have to look into whether the delay or whether it's intentionally they have ignored the pre-trial direction or so on and so forth. You don't have to know about all that. What you need to know, if I don't comply, as in the parties don't comply with the pre-trial direction, this is what the court can do, A, B, C, D. This is what the court can do. If there is a trial and you don't attend the trial, this is what the court can do, A, B, C, D. Finish. So first thing, you must know which provision to choose, 34 or 35. Okay. So we start with order 34. I'll just give you a brief description how to use order 34, a quick one, and also how to use order 35. Okay, so you need to use this book. Please open your order 34. Order 34 Rule 1. Okay, Order 34 Rule 1. If you look at Order 34 Rule 1, basically Order 34 Rule 1 is a general provision. Okay, it's a general provision governing your pre-trial case management. Okay, what I meant by general provision is that you can see under Order 34 Rule 1, let me read for you the provision. Order 34 Rule 1 Sub 1. Notwithstanding anything in these rules, the court may at any time after the commencement of the proceeding of its own motion direct any party or parties to the proceeding to appear before the court in order that the court may make such order or give such direction as it thinks fit, so that A and B, all matters which must or can be dealt with on interlocutory application and have not already been dealt with may so far as possible be dealt with, and such direction may be given as to the future course of action as appear best adapted to secure the just, expeditious, and economical disposal thereof. So this is your general provision as to what the court can do. So they can deal with any interlocutory application in order to ensure a secure, expeditious, and economical disposal. So this is the general principle under Order 34. If you go to Order 34, Rule 1, Sub 3, please star all the provision I'm telling you. These provisions are all important. General. Order 34, Rule 1, Sub 3, where any party fails to comply with any order made or direction given by the court under paragraph 1, the court may highlight, dismiss the action, strike out the defense or counterclaim, or make such other order as it thinks fit. Okay, so you see, generally, because I told you Order 34 Rule 1 itself is a general provision. Order 34 Rule 1 Sub 3 tells you if you fail to comply with the court's direction, the court can dismiss, strike out the defense or counterclaim, or make such other order as it thinks fit. Okay, you can see that is your general pro. So when you are quoting, for example, under Order 34, if you want to quote a specific provision, which I'll let you know after this what is the specific provision, you may want to quote the general one first before you go into the specific. So you can just say, pursuant to Order 34, Rule 1, Sub 3, it states that where any party fails to comply with any order made or direction, blah, 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 the court may dismiss the action and so on. Then you go to your specific provision, which I'll let you know shortly what's the specific provision for this. Okay. Then if you look at Sub 4 is nothing much. It's on the order as to cause. So the court may, in exercising the powers under paragraph 1, make such order as to cause as it thinks fit. So if I want to exercise my power under subsection 1, I can also give additional order as to cause. That's what Sub 4 is telling you. And Sub 5, any judgment or order, direction given made against any party who does not appear before the court when directed to do so under paragraph 1 may be set aside or varied by the court on such term as it thinks just. So what they're telling you, if I've given you if the court has entered a judgment or an order or anything, that judgment and order can be set aside. Can you see? Made against any party who does not appear before the court when directed to do so may be set aside. Please highlight, may be set aside or varied by the court on such term as it thinks just. So this is for the court to do. If you must apply for the judgment to be set aside, and it's for the court to decide. That is your general provision. Okay. Take note, 34 Rule 1 Sub 3 is your general provision. Sub 3 is dependent on your, Sub 1 and Sub 3 will come together. If you don't want to write Rule 1 Sub 1, you can terus go to Rule 1 Sub 3. Okay. Then you go to your Rule 2, Order 34 Rule 2. Order 34 Rule 2, you can see Rule 2 Sub 2, there's A to T. Correct? A to T. These are the list of your pre-trial direction. Pre-trial direction means what are the direction which the court can give during your pre-trial process. So they can give you anything. They can tell you must file your witness statement within this time. You must make any interlocutory application within this time. You must file your witness list. You must file your agreed facts, everything. Whatever they will then, your mediation date, everything will be governed under A to T, and any other things which the court thinks fit for your case. So A to T is not limited. Okay, there can be more to it. So the first part of Order 34, Rule 2, Sub 1, if you read, without prejudice to Rule 1, at any time before any action or proceeding are tried, the court may direct parties to attend a pre-trial case management relating to matters arising in the action or proceeding. So you can see Order 34, Rule 2, Sub 1 states that the court may direct parties, plaintiff and defendant, for example, to attend pre-trial case management relating to matters arising in the action. That's what Rule 2, Sub 1 states. And Rule 2, Sub 2, Order 34, Rule 2, Sub 2 states that what happens in the pre-trial case management? At a pre-trial case management, the court may consider any matter, including the possibility of settlement of all or any of the issues in the action or proceedings, and requires the parties to furnish the court with such information as it thinks fit and the appropriate order and direction that should be made to secure the just, expeditious, and economical disposal of the action or proceeding, including A to T. So what does it mean? Rule 2, Sub 2 states that the court can consider any issues, including a possibility of settlement between the parties and issues under A to T and extra. So A to T you can read by yourself. Generally, I just want to explain a few. It is basically filing of witness statement, filing of agreed facts, issues to be tried, how many witnesses are there, is there any expert evidence, so on and so forth. A to T is basically is all your interlocutory, what they want to decide, what they want to do before trial. Okay, let's say you never comply. Let's say after the court has given you direction under Order 34, Rule 2, Subsection 2, A to T and others, ask you to file certain things, to do certain things within certain period of time, and you never do. The you is either plaintiff or defendant. Huh? If you never do, what will happen? What is the consequence? What can the court do? Your answer is on Order 34, Rule 2, Sub 3. Order 34, Rule 2, Sub 3. This is your specific provision. This one you must start. Order 34, Rule 2, Sub 3. Okay, so you can see here, the court having given direction under Rule 2, Sub 2 or Rule 3 may either on its own motion or upon the application of any party. If any party defaults in complying with any such direction, highlight, dismiss such action or proceeding, or strike out the defense or counterclaim, or enter judgment or make such other order as it thinks fit. So can you see? If you don't comply your Order 34, Rule 2, Subsection 2 direction, or any other direction that is given by the court may, okay, the court having given direction may either on its own motion, that means the court itself, or the other party, for example, the defendant, okay, or the plaintiff, upon the application of any party. If any party defaults in complying with such direction, the court may dismiss, strike out the defense or counterclaim, or enter judgment. Okay, this is your specific provision. Please highlight for your PTCM. Then you go to Sub 4. Sub 4 talk to you about any judgment or order made under Rule 2, Sub 3 may be set aside by the court on the application of the party on such term, if any, as it thinks just. So what they're telling, in the event the court has entered judgment, okay, or any other orders the court have entered, that judgment or order can be set aside. It's not a final judgment. It can be set aside upon application to set aside, because the judgment is obtained in the default of one party. So that's why any judgment or order made under Rule 2, Sub 3 may be set aside by the court, not as of right. on the application of the party. So you need to put in an application, notice of application supported by affidavit on such term, if any, as it thinks just. Okay. Then you can put, then you go under sub 5, at any time during pre-trial case management, where the parties are agreeable to a settlement of some of all the matters in dispute in the action or proceeding, the court may enter judgment in the action or proceeding or make such order to give effect to the settlement. Sub 5 talk to you about settlement, but nothing got to do with your non-compliance. Normally, your question in order 34 is on non-compliance. If you don't comply with this provision, what will happen? If you don't comply with the court's directive, what will happen? What can the court do? So that's why I'm going to you, and what I'm giving you is only exam based. All right. So what you need to know, order 34, rule 2, sub 2, A to T, non-compliance with the directive in order 34, rule 2, subsection 2A to T or others can result in the court to dismiss your action, strike out your defense, or enter judgment or make any such order as it thinks fit. That one you can find under Order 34, Rule 2, subsection 3. And that judgment, order, or whatever that has been entered by the court can be set aside pursuant to Order 34, Rule 2, subsection 4. This is just like a map. You need to, if you understand this map clearly, Order 34 becomes very easy because your question always revolves around this area. All right. So Order 34, Rule 3, you can read notification of pretrial case management. You can see that's very straightforward that notify. Attendance at pre-trial case management, also straightforward. The parties to an action may be represented at the PTCM by their solicitor, if any, but if they so desire with the leave of court, attend the case management personally. Adjournment of the pre-trial case management, Order 34, Rule 5. This is also straightforward. A pre-trial case management may be adjourned from time to time, either generally or to a particular date as may be appropriate. Okay, one more thing. That's why I tell you, you must be very careful. If your question is talking to you about pre-trial case management and on the issue of adjournment, you must quote this provision, 34 Rule 5, or if there's an issue of adjournment. You cannot go and quote Order 35 Rule 3 if there's an issue of adjournment if on pre-trial issue. So that's the first thing you have to make sure you are clear. All right. Then failure to attend. Okay, this is another point. Failure to attend PTCM. Also, quite frequently it comes out. So you can see Order 34, Rule 6. If at the time appointed for pre-trial case management, any party fails to attend, the court may dismiss the action or proceeding or strike out the defense or counterclaim or enter judgment or make such other order as it thinks fit. Okay, same thing as above. So if they have fixed a date for you to attend PTCM and you don't attend PTCM, this is what the court can do. Okay, must take note, please. So same thing, any order made by the court in the absence of a party concerned or affected by the order may be set aside by the court on the application of that party on such term as it thinks just. Please take note, sub 2 also please take note. So very simple. In the absence of a party, an order made by the court in the absence of a party or any party who is affected by the order may set aside on the application of the party. So you see, when there's a term called application, okay, you must put in your notice of application supported by affidavit. You're making an application to court. If there is no provision stated how you want to make the application, you go by way of default. Order 32, as simple as that. Please don't confuse, don't have to ask what form whatsoever. If not stated, go by default Order 32, Rule 1 ROC, Notice of Application supported by affidavit. And then you come to your sub 3, without prejudice to the preceding paragraph of this rule, where any party to the action or proceeding fails to attend PTCM, the court may, if it thinks fit, adjourn the case management. Highlight, the court may, if it thinks fit, adjourn the case management. Okay, please take down the provisions which I told you important. 34 Rule 7 is your admission. It's straightforward. Order 34, Rule 8, please put a star. Duty to give all information at pre-trial case management, where you are bound to give genuine information during your pre-trial case management. Because the purpose is to ensure an expeditious disposal of the case, okay? To ensure that your case can settle as soon as possible. So that is why there's a duty to give all information at pre-trial case management. Duty to make all interlocutory application at pre-trial case management. Basically, if you want to make an injunction application, or you want to make a discovery application, or you want to do a summary judgment application, or whatever interlocutory application, you inform the court during the PTCM date. This is what I want to do. That is your Order 34, Rule 9. Order 34, Rule 10 is very specific for personal injury cases. Order 34, Rule 11, non-disclosure, you can read. 34, Rule 12, not important. So far, what I've given you, what is important is 34, Rule 1, 34, Rule 2, 34, Rule 2, sub 3, 34, Rule 2, sub 4, 34, sub 4, 34, Rule 2, sub 5, you can read. 34, Rule 4, you need to take note. 34, Rule 5, you need to take note. 34, Rule 6, 1, 2, 3, you need to know. 34, Rule 8, generally you need to know. 34, Rule 9, also you generally you need to know. The rest of it, so just touch and go. Okay, because your question will revolve around this area. Whatever I ask you to highlight, I will do with you a few questions. I think 4 questions. I will show you how to apply these sections. Okay. Next is your Order 35. I'm not going to do the entire Order 35. I'm going to do with you. Please take note the important ones. Order 35, Rule 1. Order 35, Rule 2. Order 35, Rule 3. That is the most important one. Okay. So if you look at Order 35, Order 35, the type, just turn your, it's just behind. Order 35 is Order 35. Look at the title itself. It states as proceeding at the trial. So that is the first thing that you need to know. Proceeding at the trial, meaning that what are the issues during trial? So in your question, you have to see non-attendance during trial or non-attendance during case management. So if your case is on non-attendance during trial, forget about whatever that I told you Order 34. The rules flip to your Order 35, try to find your answer here. Of course, you need to put some cases to support. If let's say you cannot remember, you can only use this, then you have no choice, you have to use this. That's why I'm only using the statute book to explain to you. Okay? If you look at Order 35, Rule 1, what it states in the top, failure to appear by both parties or one of them. So let's say during trial, if both parties never appear, what will happen? And if one party never appear, what will happen? That is what 35, Rule 1 states about. So under Order 35, Rule 1, Sub 1, please highlight, if when the trial of the action is called, neither party appears, plaintiff or defendant, okay, plaintiff and defendant never appear, the judge may dismiss the action or make any other order as it thinks fit. That's the first one. Okay, so both parties never appear. The 35 Rule 1 Sub 2, if when the trial of an action is called, one party does not appear. That means today the matter is fixed for trial, plaintiff or defendant never appear. I'm not talking about the counsel, I'm talking about the party. It's not the plaintiff's counsel or the defendant's counsel. It's plaintiff or defendant because it's their case. So if when the trial of an action is called on, one party does not appear, the judge may proceed with the trial of the action. Highlight, the judge may proceed with the trial of the action or any counterclaim in the absence of that party, or without the trial, give judgment or dismiss the action or make any other order as it thinks fit. Let me explain to you what they have stated here is that if one party do not appear, okay, what the judge can do, the judge may proceed with the trial of the action, first thing. Second thing, proceed with the trial of the action or a counterclaim. I think you all should know what's a counterclaim. You all know what's a counterclaim, right? In a counterclaim, The defendant become the plaintiff and the plaintiff become a defendant. It's like a cross thing. Okay. So the first one, the judge may proceed with the trial of the action or the counterclaim in the absence of that party, or without a trial, enter judgment or dismiss the action or make any other order as it thinks fit. This is within the discretion of the court to make any other order as it thinks fit. Okay, so these are the powers which the court have, which the court can do if one party does not appear. Okay, let's say the court have entered judgment. That's when you come to sub 2. So if you look at judgment given in the absence of a party may be set aside. Any judgment under Order 35 Rule 2 subsection 1, any judgment or order obtained where one party does not appear at the trial may be set aside by the court on the application of that party on such term as it thinks just. So please highlight any judgment or order obtained where one party does not appear, okay, at the trial may be set aside. Please highlight may be set aside by the court, once again, on the application of that party. So if let's say one party never attend, the court enter judgment for, let's say, the plaintiff, that judgment that has been entered for the plaintiff, all right, can be set aside upon the application of the defendant. For example, why is not an appeal? Because that judgment is not heard on the merits of the case. It is merely technical error, technical rules. The judgment has been entered. So that judgment can be set aside under Order 35 Rule 2. Take note, please highlight that part first. So an application under this rule, highlight once again, application under this rule shall be made within 14 days after the date of the judgment that is sought to be set aside, without prejudice, however, to the power of the court to extend the period. So what does it mean? Once I get the judgment or the order, I can apply to set it aside within 14 days. Okay, if you exceed the 14 days period, you may put in an application to extend time under Order 3, Rule 5. Procedure, once again, notice of application. Support have given you extension of time, then you apply to set aside. Okay, that is what they're trying to do. So what are sub 3, Order 35, Rule 2, sub 3, what does it state? In deciding to set aside, so in considering an application made under this rule, the court shall have regards to the matter in A to E. So in order for the court to set aside the judgment, the court will see, in the interest of justice, whether the absence of the applicant or the counsel will deliberate or due to an accident or a mistake, the prospect of success of the applicant at the trial, whether there's any delay in making the application, whether the conduct of the applicant has caused prejudice to the other party, which cannot be compensated by an order of. So these are the factors where the court will take into account to consider whether to allow your setting aside application. You see, you may have case laws to add on to this. Okay, I have no issue if you have case laws to add on to this. But let's say during exam, you cannot remember. You only have this book. Okay, you only have this book with you. So if you have this book with you, you just use the factors that is stated over here if you cannot remember. But if you can remember, okay, if you can remember, you have additional case laws you want to add on, can, no issue. What I'm giving you a simple way as to how you are going to do this. If the questions comes out on Order 35, how you are going to answer it. Let's say you cannot remember, you have a 10 marks question, you still can score 7.5 or 8 without your case law, provided you have your proper, you have cited the proper section, your subsection, and you have write properly, clearly with a conclusion. No worries, 100% you can pass the paper. Okay, this is your, you must know how it works. You must know how it works. It's just like a format. 34 and 35, it's like a format. And then order 35, rule 3, very simple. It's on adjournment. Okay. Adjournment, you have no choice. Adjournment, if you look at it, there are 10 marks question, 8 marks question. So just by cite, if there's a question on adjournment, just you think by citing order 35, rule 3, I can get, if it's 8 over, if it's 10 marks, I can get 8 over 10 can. Okay, why cannot? Because not enough. So you see, the judge may, if he thinks it is expedient in interest of justice, adjourn a trial for such time and upon such term, if any, as it thinks fit. Correct? That's all it is given. So for this kind of question, what you must do, you have to add on your practice direction, 1 stroke 2019. I have the case of Insas Berhad versus Ain Molek. If you don't want to use that case, that's fine. You must use Diana Chung's case. If you don't want to use the case, you have other case, that's fine. So these are the cases which will help you to add on to your order 35, rule 3. That means on the issue of adjournment. If let's say it's just a 5 marks question on adjournment, yes, you can write this only, order 35, rule 3, relate to the facts and maybe one case or maybe practice direction, that's fine. But if it's a 10 marks question, you cannot do that. You cannot just put 35 rule 3 and just dismiss it. You need a little bit more, little bit of addition to add on to your answers. Okay, order of speeches and all, you do it. Very simple. What I'm giving you is exam based. Okay, so you need to know how to apply 35 rule 1 sub 1, 35 rule 1 sub 2, 35 rule 2 sub 1, sub 2, sub 3, A to E. No need to memorize. Everything is there. You just have to know it is there. It is there where to find my answer. And adjournment, order 35, rule 3. Same thing. If the question is on trial, on adjournment, you go to 35, rule 3. Not your order 34 adjournment. If you are going to do that, but you're going to tell me, oh no, both is adjournment. What? Yes, you are right, but wrong provision. Wrong provision, they cannot accept. Okay, okay. I'll give you the questions. Please take the questions down first. July 2013, question 5. July 2013, question 5. A and B. July 2013, question 5, A and B. October 2014. October 2014, question 7, A, B, C. Okay, let me just explain a little bit. October 2014, question 7, A and B has nothing got to do with PTCM. But never mind, please do it. It is straightforward. I want to make sure I finish the 25 marks question. Total is 25 marks. 7A, B, C. Take note, October 2014, 7A, B, C. And then the other one is November 2015. November 2015, question 2A and C. If you look at November 2015, 7 marks question. It's like an essay question, but it is straightforward. 7 marks question. 2C, if you look at it, this is what I was telling you on the issue of adjournment, 10 marks. Okay, 2C, November 2015, 2C. And then the other one more is August 2016. August 2016, question 3C. August 2016, question 3C. Okay, August 2016, question 3C is also not on order 34 or order 35, but I just want to show you how the question repeats. Okay, I just want to show you how the question repeats. So it will be easy. If you prepare for one, you know the rest of it is the same answer. all of you have taken it down? Done? Okay. Okay, before I discuss with you, I want you to read that first question first in full because that question is a bit long. One minute now. That question, July 2013 question 5, it's quite long. I want you to put the parties down. How will you do it? Okay, how will you do it? Just brief answer, just brief answer. Then I discuss with you. I give you all 15 minutes, not only for that question, the rest of the question, because if you look at the rest of the question, it's straightforward. Even you, if I just want you to practice first before you give me the answer. 15 minutes to 20 minutes roughly, especially the question 5, it's very, very long. Okay, we need to know, take down the parties, take down what they are telling. Then you see you can relate which provision you are going to choose to let me. 10, 15 minutes. 15 minutes fine? Okay, 15 minutes. Please do, and the rest of you, please do take it as an exercise before I give you the answer. Otherwise, if I give you my answer, you will say yes, 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 correct. Okay, only when you try, you will know. I go through the facts with you all, then we take it down one by one. Okay, because I'm not sure whether you all understand the facts or not. So, all right. So if you look at it, Overseas Sendan Berhad employed Alex as their branch manager at Jitra Kedah. On 30th April 2013, Overseas terminated Alex's employment contract due to his misconduct. Despite the termination, Alex continued to come to the branch and interfered with the company's operation. Overseas Berhad sued Alex at the session court for trespass. Alex, on the other hand, countersued Overseas for wrongful termination. Okay. This is the first thing you need to answer. Now, understand, this is not a separate. It is this. Can you all see this board? Can you see? Okay. First thing you need to understand. Overseas, just put here. This is Alex. Okay. For trespass, correct? This is the main suit. Alex countersuit. The term that they use here is countersuit. That means, in another word, it's a counterclaim. Okay, I know the term is a bit confusing. Can you see? Is it clear? Can? Okay. So the term that they use over here is countersuit. For Alex countersuit overseas for wrongful termination. Alright? This whole thing, you need to understand this. This whole thing is one suit. One suit. Under one suit number, for example, one suit number A5, whatever, 11, 20, for example. All this is one suit. You understand this? This is the first point you need to take note. Counter suit means it's a counter claim. Okay, not a set off, it's a counter claim. Okay? Oh, sorry. Done? Copied this ready? Okay, that's your first paragraph. Then you can see, on the day fixed for trial, Alex and his counsel was present. Clear? Overseas done by that versus Alex. On the day fixed for trial, counterclaim, right? Counterclaim, here's the main suit, right? Here, Alex and the counsel was present. Agree? Second paragraph, agree? With the facts? Okay. Alex and his counsel were present. The counsel for overseas was present, but not their witness. Here, counsel present, but Witness not present. Okay. Counsel is present. Witness is not present. The session judge indicated to the parties that since overseas Sandan Berhad is the plaintiff, okay, and their witnesses was not present, he was minded to dismiss overseas claim and enter judgment for Alex on the counterclaim. So what paragraph 2 is telling you, for the first claim, overseas Sandan Berhad versus Alex for trespass, the judge wants to dismiss the claim because the witness is not present, okay? And for the Alex's counterclaim, this part, he wants to enter judgment for Alex. Judgment for Alex. That means for the benefit of Alex. Take note, all right? Judgment for Alex on his counterclaim. Paragraph number 3, the counsel for overseas sought an adjournment from the court on the ground that May Tan, the managing director of the company, who's also the only witness for the plaintiff, has just left for China the night before because her father was suddenly admitted to the hospital there a day before. Alex's counsel objected and said that he was informed of this request for an adjournment the day before. The session court judge refused to grant the adjournment because he was of the view that parties must always be prepared on the day of the trial. Very simple, don't bother. What you need to know, this fellow overseas applied for an adjournment due to non-attendance of his witness. The judge refused. That's it. That's all. Okay. Alex objected to the adjournment. That's it. Just summarize paragraph 4. Don't bother whatever, where is he, what, that one, not our concern. Okay. Counsel for overseas then submitted that the plaintiff's claim can be determined on a point of law. So what they did, adjournment not granted, correct? Adjournment not, I applied for adjournment, overseas applied for adjournment not granted. Okay, adjournment not granted. I short form, I just short form. Adjournment not granted. So what he did, the only option that he submitted the plaintiff's claim can be determined on a point of law. That is whether Alex has the right to come to the branch office after his contract of employment had been terminated. And if Alex has no such right, he is therefore a trespasser. So that's what this guy had submitted. Okay, so he's telling that end of the day, I can determine my case on a point of law. Okay, which is under Order 14A. Since the parties had agreed to the fact of termination, the hearing can still proceed without calling witnesses to give evidence. This is what overseas is stating. So, even there's no witnesses, my trial can still proceed because my action is only, now I'm telling that my case can proceed only on question of law. All right? Then you go, as regards to Alex's counterclaim, counsel for overseas addressed the court that after Alex has given evidence, he would submit a no case to answer as he does not intend to call any evidence. So he's saying on the issue of this counterclaim, this is on the counterclaim, after Alex, I told you right, in the counterclaim, the defendant becomes the plaintiff. So once Alex has given his evidence, after Alex's evidence, overseas Sandan Berhad will put a submission of no case to answer. No case to answer. This is what they are telling on the issue of the counterclaim. Okay. Rest, there will know some, and he does not intend to call evidence. Then last paragraph, session judge disagreed with the above submission. So the judge is telling, I don't agree with what you are telling, that your case can be determined in Order 14A. I don't agree on that. I don't agree on your submission of no case to answer. This is what the judge disagreed. Okay. He held that there was no necessity to hear Alex's evidence. I don't have to even hear his evidence. He proceeded, that means the judge proceeded to dismiss overseas Sandan Berhad claim and entered judgment. So for the first suit, overseas was Alex, he dismissed the claim and entered judgment for Alex. Okay, are you clear with the facts? Is the facts clear? Facts must be clear first. Is the facts clear? All okay? Don't see anything in the chat box. Okay, yes, all right. Now, let's go into the question. The first thing I want to explain, although they have mentioned the order 14A and everything, this question has nothing to do with order 14. Nothing, zero. This is the first point you must understand. If you have made, if you answer now, whatever answer that you have written, you have put something in order 14A, I'm sorry, the answer is wrong. You see, just because they have stated their order 14A, you cannot do that, You have to look at the question, what the question is asking you. So there, if you look at 5A, they ask you on the issue of adjournment, on the issue of dismissal, on the issue of the judgment. That's it. With 15 marks, allocation given ready. Just go on that point. Okay. You see, this is just a style of writing, how you're going. Some of them, they write everything together. 1, 2, 3, they champo everything, they do it together. My style, I'll put comments 1, the adjournment, I put my answer in paragraph. Number 2, on the issue of the dismissal of the claim, I put my answer in paragraph. And then sub 3, the judgment for Alex, I put answer in paragraph. That's just my style. But if you are not that type, you just use your style, but must be in paragraph format. Okay, you cannot put dash, 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 dash. Cannot. Okay, they will not mark you even you have answered correctly. You cannot do a dash, dash, dash in your exam. This is important. So if you look at this, advice overseas, they're asking you to advise the plaintiff on the decision by the session judge in relation to 3 issues. Share the answer a little bit. You can you all see? Cannot? Can? Okay. So I just put the brief facts down. Overseas versus Alex for session court for trespass. Just now I explained this to you. Wrongful termination. During trial date, Alex and counsel present. Overseas Sanjan Berhad counsel present, but witness not present. Judge informed since plaintiff and witness are not present, intend to dismiss their claim and enter judgment for Alex. All this I explained to you just now. Overseas counsel applied for the adjournment. Alex objected. Judge never grant the adjournment. Okay. Overseas counsel said his case can be determined on a point of law. On the issue of the counterclaim, Overseas states that once Alex has given evidence, Overseas will submit a no case to answer, as he did not intend to call witness. All this don't have to put in your exam. No need. This one I'm just telling you how, the brief facts, so that because that's too long, right? So that I'm just explaining the thing to you. You don't have to do all these things, okay? Decision, disagreed with the submission. Whose decision? The judge's decision. Disagreed with the submission. This overseas claim and entered judgment for Alex counterclaim. Okay, that's all. So your question here is advice on the issue of adjournment, correct? Let me look at, before I go into this, I want to explain this thing to you first. Okay. This is a 15 marks question. Students always have problem. How much to write? 15 marks, how much I'm going to write? Okay. For this question, it's okay because they've given you 1, 2, 3. So what you can do, 5, 5, 5 marks. Okay. Average 5, 5, 5 marks. So you can see if 5 marks, how much am I going to write on adjournment? If dismissal, how much I'm going to write? Judgment for Alex, how much I'm going to write? That's all. Some question, they don't give you that. They don't give you a breakdown. Romans 1, Romans 2, Romans, no. They just lump everything. They say 15 marks. Then, okay. If you know the question well, you can put whatever that is relevant there for the 15 marks. But my style is normally just don't bother the marks, just answer what is relevant. Okay, don't bother the marks, meaning that it doesn't mean that 15 marks you have to write 2 pages. No, 15 marks you can still write 1 page, or maybe 3/4 of the page you still can score. You need to understand, you need to give the correct answer. Okay, it's not LLB way where you write everything down you think you can get. For me, direct on point, case law, you support your answer based on case law, give your conclusion. You need to follow this style. I don't know how many of you all know. Easy way is follow this style. Good luck. This is brief facts. You don't have to write in your exam. Most of the time, you don't have to write like the brief facts, okay? Next is identifying the issue, okay? Identifying the issue in question. So the issue here in question is the three issues. They're asking you to comment on the adjournment, the dismissal, and the judgment. This is the three issues. What is the law in relation to the issue? What is the law in relation to the issue? Okay, this is where your order 35, order 34, whatever order comes in. Application. Now you know the issue, you know the law. How you apply the law and the issue to your facts. How you apply. So you must say on the facts, pursuant to this order, this what has taken place. Okay. And lastly, this is what students always miss. This is what carries your mark. This is what makes an A or a B or a pass or a fail. Honestly, this is what your conclusion. Doesn't matter your conclusion right or wrong, but you must have a conclusion. Basically, your conclusion, you're telling that based on this, what will happen? Based on this, what will happen? That's all. Doesn't matter right or wrong, it's okay. As long as you give your conclusion based on this. Don't put your issue, your law, your application is something else. Your conclusion has nothing got to do with your issues. That means you're conflicting yourself. You cannot do that. Whatever issue, law, application, you relate to your conclusion. Your conclusion must mirror your issue, law, and application. Very important. Huh? Although it looks like a very small thing, your conclusion looks like a very small thing, you need to have your conclusion. Doesn't matter, not only civil, evidence, any paper, GP or whatever paper you are doing, you still need to have your conclusion. You need to know this way. Those who don't know how to answer, how am I going to write a question? You need to know this. This is the simplest way how you can answer. You need to know this format. This is just like a template. Okay? BILAC. Okay? Okay. So the first part, advice on the issue of adjournment. So okay, let me ask you which order you must use, 34 or 35? Which one you should use, 34 or 35? At least in the chat box, someone. Okay, it's 35, right? Why? Because all this took place during trial. So forget about your order 34. Teach your order 34. So if you go to order 35, okay, you can see advice overseas, right? On the issue of adjournment. Session court refused to grant the adjournment on the issue of adjournment. Order 35, rule 3, I use one case. You don't want to use, it's okay, no problem. Where the court has discretion to grant adjournment as it is not automatic upon request. So here I put see practice direction 1/2019 on the guidelines of the adjournment. If you are using any, whatever book that you are using, you can just refer to it on the issue of adjournment. I will just read out to you. I don't want to put in the answer. I will just read out to you what are the guidelines that you may need to write. If you don't want to write, also can, but I will just give it to you. What are the guidelines that you need to write on the issue of adjournment? Okay, you can see the defendant has the right to be legally represented. It's definitely in one of your book, definitely it's that. The counsel is on vacation or attending a course or seminar without informing the court in due time is not a good reason. The counsel who has fallen sick is sufficient reason for postponement provided MC is presented to the court. If it's the first application for postponement, it is not sufficient reason to allow postponement. Involvement in other case is also not good reason to allow postponement. On top of the practice direction 1/2019, the court will also consider some other factors. Number one, whether the adjournment that is requested for is first time and whether the adjournment requested after several times, who is requesting for the adjournment, plaintiff or defendant or his solicitor. On our facts, Overseas Sdn Bhd is requesting for the adjournment, who is the plaintiff, because client cannot attend. That means there's no witnesses in court on that day, whether there are good reasons to grant adjournment. You can have many cases. You can also go with Go Pak Ho, Lee Ati, Diana Chu, any cases, up to you. Okay. I just put Insas Berhad Ayat Molek because I look at the question as just 5 marks question. I think number Romans 2 and Romans 3 you have more to write. So that's why I just stop at practice direction and the balance of it. Then after you have applied this thing, this whole law, you have to explain Order 35 Rule 3. You just copy paste from your rules of court. You use this case, then you say court has discretion. Then you can say the fact that the trial judge, the fact that the session judge did not grant an adjournment, okay, is based on the court's discretion and the judge does not err in law. Okay, the decision of not granting the adjournment, nothing wrong, because it's the discretion of the court whether to grant or not to grant. That's what they want you to comment on. So you put your conclusion. That's your conclusion. Now you have given the issue, the law, you have applied it, and you have given a conclusion. If you look at it properly, my style of writing, direct to point, straightforward, and I'll do it that way. I don't like to mess up everything. So that's why if you see, I've ordered 35 Rule 3. I support with my case, insas, and also practice direction. I relate to the fact the trial judge discretion not to grant an adjournment. Nothing wrong. That means the judge did not err in law, and that's the conclusion. Finish ready. Okay. If you want to add on one thing, let's say you want to add on whether the appellate court can interfere. You want to put can, but for me in this question, it is not necessary. Whether MGG Pillay versus Vincent Tan, you want to put that case also can. But if you don't want to put, for me, I will not put because I think it is not relevant to see whether on the issue of whether appellate court can interfere. One more thing you must understand, it doesn't mean that if you put everything inside, you will gain that marks. No, they're just asking you to comment the fact that the session court judge never didn't grant adjournment, right or wrong. You have mentioned, you have stated it is not wrong because end of the day is the discretion of the court whether to grant or not to grant adjournment. Okay, simple. The second part is on the issue of dismissal. Okay, this one I want to see your answer. I want to hear. Anyone can put in the chat box. It's not one of them put ready. I want to see your answer on the issue of dismissal. What did you all write? The dismissal of overseas claim. Right or wrong? Can the judge do so? If can, which provision under the rules of court which allows the judge to dismiss overseas Sendirian Berhad claim due to non-attendance of the witness? Please put in the chat box or anyone want to give an answer also can. Order 35, Rule 1, Subsection 2. So you all are quoting Order 35, Rule 1, Subsection 2. Correct? So you have mentioned Order 35, Rule 1, Subsection 2, where the court has the power to dismiss if one party do not attend court. So Order 35, Rule 1, Subsection. So if you look at it, overseas claim was dismissed without hearing the parties. Same thing as I quoted Order 35, Rule 1, Subsection 2. Just copy paste what is stated in Order 35, Rule 1, which is Order 35, Rule 1, Subsection 2, where in the trial of an action is called on, one party does not appear, the judge may proceed with the trial or the action or any counterclaim in the absence of that party, or without trial, give judgment or dismiss the action or make any other order as it thinks fit. I'm taking directly from your statute book. Directly. If you don't want to write so much, you think you know how to paraphrase, then just paraphrase, but don't wrongly paraphrase. Wrong, the whole thing goes wrong. Okay. So if you want to quote directly, my suggestion, if you don't know, please quote directly, but quote together with your order 35 rule 1 sub 2. Then I add on this case. I'm not sure whether you all have this case in your book. I think you should have, when New India Assurance versus Karam Singh, where the plaintiff can file a fresh action if limitation period has not expired, because now their claim has been dismissed, correct? His claim has been dismissed. He can refile a fresh action if limitation period has not expired. That's what I'm using this case. Okay. If you don't have this case, it's okay. You can use any case that you have. Next will be judgment. Judgment. Next is your judgment for Alex. What you have written on this part? Judgment for Alex. Judgment for Alex is on the counterclaim, where the court has given judgment for Alex on the counterclaim. Right or wrong? So they are the advice overseas on the decision of the session judge in relation to the judgment for Alex. So what? Now your client is overseas. What you can, the first thing you comment as to the session court judge decision. If you think the session court judge decision is correct, what you can advise Alex to do, sorry, what you can advise overseas to do. What is the next step? You can put the answer in the chat box. Huh? One of them give me the correct answer. Anyone else? Anyone else? You want to check your answer. If you want to check your answer, if you have done, you want to check your answer, please put in the chat box. None? No one else? Okay. Nobody? You see, now judgment has already been given, correct? 35, the judgment is valid but can be set aside. Okay. So you see, judgment has already given to Alex on the counterclaim. Overseas Sudan Berhad versus Alex. On the issue of counterclaim, you now see. Can you see the board? Can you all see, please? Because I can't see you all. Can you all see? Okay. Court has given judgment to Alex. First thing, you must comment whether the session court judge is correct or not, right? Alex has no witness. Once again, same order. 35, rule 1, subsection 2. When one party does not appear, the judge may proceed with the trial of the action or any counterclaim in the absence of the party, or without trial give judgment. So, pursuant to order 35, rule 1, subsection 2, the judgment that is given on the counterclaim is correct, right? Next, you are to advise overseas Sendirian Berhad. So, under order 35, rule 2, subsection 1 verse, subsection 1, one party who does not appear may apply to set aside the judgment of the order. That is your sub 1. Application to set aside must be done within 14 days, subject to the power to extend time. That's your sub 2. And your sub 3 gives you the factor to set aside, correct? Your sub 3, A to E. gives you the factor to set aside. So this whole thing must be in your answer. This whole part must be there in your answer. So if you look at it, this, when the matter is set for trial, okay, overseas wants to make a submission of no case to answer, but the judge is of the view that Alex does not have to give evidence, blah, blah, blah. So when the matter is set for trial, one party does not appear, the judge may proceed of the action. The judge may proceed with the trial of the action or any counterclaim in the absence of the party, or without trial give judgment or dismiss the action or make any other order as it thinks fit. On the facts, Alex is present, but overseas witnesses are not present. Hence, pursuant to 35 Rule 1 sub 2, the judge may proceed to enter judgment for Alex. However, it should be noted that a judgment or order that is obtained when one party does not appear can be set aside by the court on the application of that party. Overseas, Sendirian Berhad. I relate directly already. One shot I put together. Order 35, Rule 2, subsection 1. Application to set aside the judgment should be made within 14 days after the date of the judgment, but the court has the power to extend the period. Okay, Order 35, Rule 2, subsection 2, and the factors in Order 35, Rule 2, subsection 3 will be considered by the judge in the setting aside process. Actually, you can put Order 35, Rule 2, subsection 3, A to E. Okay, you can add on A to E. Therefore, overseas is advised to apply to set aside the judgment entered for Alex within 14 days. If more than 14 days, apply for an extension of time under Order 3, Rule 5, Procedure, NASA, blah, 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 and to provide good reasons for the setting aside application. So all this, I have put into one paragraph. Okay, all this I've put into one paragraph. If you cannot write like this, you are the type to write one after another one. Doesn't matter, just write one by one. Just write one by one, provided all this is there. This is simple, huh? All this is there. Also apply. No. Party cannot apply to witness. You mean party means which witness? Any party, plaintiff or cannot apply to counsel. The word party is plaintiff, defendant, parties in the proceeding, not counsel. Okay, not counsel. Can? Okay, then you add one part. This one is just a small part on. Okay, this one, right? This part, right, is on the issue of submission of no case to answer. Basically, you must understand, submission of no case to answer. This one I just write here just to explain to you all on the issue of submission of no case to answer. Submission of no case to answer is actually very simple. The only thing is that what you all must understand about submission of no case to answer, you can only, it's not as of right, you can only make a submission of no case to answer if you are of the view that the plaintiff has not established a satisfactory case. If the plaintiff has not established a satisfactory case. Here on our facts, who making a submission of no case to answer? Who is making a submission of no case to answer? Overseas, right? Address the court that he would submit a no because it's a counterclaim. In the counterclaim, Alex becomes the defendant. Alex becomes the plaintiff. Overseas becomes the defendant. So overseas is making a submission of no case to answer on that part. So here, it's not the answer. I've just given you on the issue of submission of no case to answer. That's all. Later when I send this list to you all, I send you this answer. I send this answer to you all. I just want you all to relate. I just want you all to read how submission of no case to answer works. It is not applicable for our question. At least I will not write on the issue of submission. I've related the issue here on the issue of submission of no case to answer, but you don't have to put it in your answer. Your answer just 1, 2, 3. That's it. Answer 1, 2, 3. I repeat, please, please, please don't put submission of no case to answer in your question. Your question is just about 1, 2, 3. That's it. Okay. Here, this part of the answer, okay, will go for your question B, not for your question A. Your question A is only 1, 2, 3. That's it. Finish. Full stop. Okay. Don't put anything on submission of no case to answer in question A. Please, I repeat. All right. So if you go to, this is how you are supposed to do it. 1, 2, 3. This is how you're supposed to do it. Okay. If you go to part B, part B. Counsel for Overseas advised them to file an appeal against the decision of the judge in entering judgment for Alex, but as regards to the dismissal of their claim, the proper way is to file the action afresh instead of making an appeal. Counsel for Overseas advised them to file an appeal against the decision of the judge in entering judgment for Alex. Correct? On the issue of the counterclaim, they are telling you file an appeal. Let's go one by one. There's two questions to this. If you look at it, there's two issues here. First issue, they are advising, Counsel for Overseas is advising them to file an appeal against the decision of the judge in entering judgment for Alex. That is for your counterclaim. Okay. But as regards to the dismissal of their claim, the proper way is to file the action afresh. So the claim between Overseas Sendirian Berhad versus Alex was dismissed, right? For this claim, the counsel is telling you file afresh. Here they are telling for the counterclaim on the issue of judgment. There's a judgment given for Alex, right? They're asking you to, they're advising to file an appeal. Now, do you agree with this advice? Do you agree with this advice? 10 marks. Not an easy question. Okay, not an easy question. Only if you know what is the distinction between a dismissal, filing afresh, then you will be able to do this question. Okay. In simple terms, I want to explain to you in simple terms. When your case, okay, plaintiff's case, defendant's case, okay, when your case is heard on the merits, then what does it mean by heard on merit? That means witnesses are there, the plaintiff witnesses are there, defendant witnesses are there, okay. Everyone is there, cross-examination take place, okay. Defense is called, defense close case, cross-examination take place, re-examination take place, everything take place. At the end, during judgment, the court decides, the court's decision is dismiss. Please take note, this one is very, very important. Let me stop sharing first. Stop. Please take note on this. I repeat, plaintiff's case, defendant's case. Okay. Witnesses are present for both parties. There's examination in chief, cross-examination, re-examination for the plaintiff's case. For the defendant's case, same thing. Examination in chief, cross-examination, re-examination. All done. During judgment, court gives judgment, decision, they have dismissed the plaintiff's claim. Dismiss the plaintiff's claim. So now you got a judgment on dismissal. What you should do. At this if the decision is like this on this issue, it means upon hearing the party's case on merits, the court have dismissed the plaintiff's case. The plaintiff is advised to file an appeal. Why? Because the court has heard the case on merits. Cross-examination has taken place. Trial has taken place. Evidence are exchanged. Everything is exchanged. You already have a judgment. Just that the judge is not satisfied that the plaintiff has established a case against the defendant. So the judge dismissed the case. You are not satisfied with the order that is given by the judge. You appeal. Let the appellate court to decide. This kind of situation, this kind of situation. Okay. Another situation is like this, like on our facts. Another situation is like on our facts where judgment is given for Alex's counterclaim without hearing the parties. That means there's no cross-examination, nothing. The judge is just telling that I cannot accept your submission of no case to answer. I don't agree with your submission of no case to answer. You don't have to make a submission. Your witnesses are not there. I'm going to use my power under Order 35, Rule 2 and enter judge, Rule 1 sub 2 and enter judgment for Alex. In this kind of situation, your evidence, your case is not heard on the merits. Your case is not heard on the merits. So the judgment that is entered here for Alex's kind of a situation, you cannot appeal. Cannot appeal. First thing, it is not on merits. Second thing, the judgment that is entered is actually only in the presence of one party. Only the counsel is present there. How about the other party? Nothing. So the only option that you have here is when the matter is not heard on merits, you set aside. How to set aside? Rule 2 have given you the way to set aside. This one is where evidence are not heard on merits. The earlier scenario that I've given you, there was exchange of evidence, cross-examination, and both parties were there. Both parties were there, everything were there, everything was open, just that the judge is not agreeable. So when you're not agreeable, you cannot tell, I want to set aside. You cannot set aside because it's already a final judgment. This is not a final judgment yet. You get me? This judgment is obtained basically on technical grounds, I said. So the only way for you is to set aside the judgment. To set aside the judgment. So the first answer, the first part of the question where they have asked you, counsel for overseas advised them to file an appeal against the decision in entering the judgment for Alex. Okay, so the first one is wrong. So you can put, I will send you the thing later on. This way I explain on the submission of no case to answer, what will happen, and blah, blah, blah. I explain on this thing. You can read on the issue of submission of no case to answer. Okay, then I put here, last year, where's this? So say hence the proper cause here would be set aside instead of an appeal. Okay, you need to read because it's almost similar. I will send it to you all later on. You can read this thing. Okay. On the issue of the dismissal, so you look at the second part of the question. But as regards to the dismissal of their claim, the proper way is to file the action afresh instead of making an appeal. Correct? That is what they ask. That is what they have advised. So for your first action here, remember the trespass one, overseas versus Alex. Now that action has been dismissed. Correct? The first part over here, as regards to the dismissal of the action, can you see? On the issue of dismissal of overseas claims, since the matter was not heard, the plaintiff can file a fresh action if limitation period has not expired, as can be seen in the case of New India Assurance versus Karam Singh. So I'm agreeable to this view. The first part, I'm not agreeable. The second part, I'm agreeable to this view. You may have a different case from me, from your book, doesn't matter. What you need to know is just the point. Okay, the point whether can, here the issue is they have already dismissed the whole action, correct? They have dismissed the whole action on the issue of the dismissal of overseas claim. Since the matter was not heard, the plaintiff can file a fresh action if within limitation period. Limitation period has not expired. I'm not sure what case you all are having, but this is one case on point that you can see. One more thing, if you cannot do this kind of question, you already know here, first is 15 marks, second is 10 marks. You don't have enough sources or authority to do this kind of question. Please don't do. Please don't take the risk of doing this kind of question if you cannot do. Because why I'm telling you is that even here you can do for the 15 marks, if the 10 marks you cannot do, they are not going to mark you here for over 15, right? Definitely they're going to give you a lesser mark. Let's say you get a 10 or 11. But here 10 marks, let's say you don't know how to do and you get a 0 or a 2. It's a bit dangerous, I would say. A bit dangerous because you are just there between 10 to 12 over 25. So don't choose this kind of question. It's very important that you choose a good, you will choose a good question where you can answer. Okay, so this one, why I'm giving this question to you, why I'm giving the answer for this to you, at least you will see how to answer. Okay, some of them use article to answer question B. They give a case law, they give an article to answer question 10. That is up to you. You see, if you know, okay, if you're going to spot this kind of question is coming out, if you know, then okay. But if you don't know, how will you know I should give an article or what? You get me? So my suggestion is only if you know how it works entirely, then you do. If not, please don't do this question. Don't do this. Don't do this kind of question, the B part. The A part is still okay. All right. Now you go to October 2014, question 7. October 2014, question 7. Okay. If you look at October 2014 questions, can someone give me the answer first before I give you the, what's the answer for 7A, October 2014, 7A? Anyone, just put in the chat box. Discuss the statement, the court has discretion whether to allow a proceeding irregularly commenced to continue or to be quashed with specific reference to the provision of the rules of court and the decided cases. Anyone in your chat box? What they're asking, what they're telling you. If any proceeding which is irregularly commenced, whether the court has discretion to allow the proceeding to continue or to quash. So you are to state the relevant provision. So whether it should be begin by read or OS, correct? So what is your answer? Correct what you're telling Sandeep. So what's your answer? Order 2, order 1A. Okay, see, this is the general, that's not the answer, not order 2, order 1A. This is the general mistake, I would say common mistake which students are doing. Okay, how many of you order 2, rule 1, order 1A? Order 2, rule 1, order 1A. How many of you? Sandeep is order 28, rule 8. Someone, anyone else? You all need to give me, then you will know. If you make a mistake, now you can correct your mistake. But if you don't want to try, you will not know what to write in the exam. Order 2, 1. Okay. You see, here, it's a bit tricky. Even you look at it, very straightforward. No. Well, if you look at it, the court has discretion whether to allow a proceeding irregularly commenced to continue or to be quashed. So let's say I commence an action by way of an OS. Let's say I commence an action by way of an OS. The question is asking you whether a proceeding irregularly commenced. So I commence a proceeding by way of an OS. Okay, this shouldn't be the actual mode. It should have been by way of a writ. So can this proceeding by way of an OS still continue or can be quashed? That's what the question is asking. The answer is can continue. How can continue? Order 28, Rule 8 states that the court has discretion to convert the OS. I'm just summarizing Order 28, Rule 8. The court has discretion to convert the OS to a writ. Okay, and the court must give direction as to the pleadings. Chow Chiu Kun versus Abdul Johari's case, or Ting Ling Q versus Ng Iron Works. This type of question repeat. Why you cannot use order 1A? This is technically, the question is not asking you on non-compliance of the rules. It looks like non-compliance of the rules. This is not non-compliance of the. This is basically, if I have comments on the wrong mode, can I convert it? Or I cannot, the court will quash my whole proceeding, I refile only. That is what they're asking. There 7 marks is actually only 3 things. Order 28, Rule 8, Chiao Chiu Kun versus Abdul Johari. Why you need to have Chiao Chiu Kun versus Abdul Johari? Because Chiao Chiu Kun, I think Gopal Sriram's judgment, when we have mentioned that upon conversion, the court will give you direction as to your pleadings. That means what to do. And Ting Ling Q versus Ng Iron Works. Ting Ling Q versus Ng Iron Works endorsed Chiao Chiu Kun versus Abdul Johari because in Ting Ling Q there was fraud, conflicting evidence on affidavit, but they start off with an OS. So that's why I use these three provision to answer this question. Okay. I want you to understand. I'll give you the answer later on because I don't want you all to look at the answer then give me. I want to see your answer first. Okay, I'll give you the answer later on because it's already a full answer. You can look at it. Okay, question 1. So your 7 marks, very simple. You don't have to write anything like extraordinary, nothing. Follow statute 2. Order 28, Rule 8, right? But of course, you must memorize Ting Ling Q. Sorry, you must memorize Chiao Chiu Kun, Abdul Johari. I'm sure you all have it in your notes. I'm sure you all have that case. How many of you don't have Chiao Chiu Kun versus Abdul Johari? How many of you don't have Chiao Chiu Kun? Okay, if you don't have it, it's in my answer. You can take from my answer. Okay. Question number 2. Proceeding may begin by a writ or an OS. 6 marks. Sorry, 6 marks. The question is telling you, discuss. That's it. Proceeding may begin by a writ or an OS. How are you going to do? What will you put? For 6 marks, what will you put? Order 5, Rule 1, Order 5, Rule 2, Order 5, Rule 4, Sub 1, whether there is substantial dispute of fact, right? Anything else? Anyone, anything else? Okay, correct. Your answer is there. Order 5, Rule 4, Order 5, Rule 3, Rule 2, Rule 1. And then I add on 2 cases. Basically, what you must have, what is the element of a writ? What is an element of an OS? So if there's any dispute, you go by way of a writ. If there's no dispute, you go by way of an OS. A case to support. Why I use a case to support? Because it is 6 marks. Sia Chun Chai versus Saraswati Devi or Abdul Majid's case. You can use these 2 cases. Up to you all. Up to if you have other cases to support, then you can. Sia Chun Chai versus Saraswati Devi states that if there is substantial dispute as to facts, you need to proceed by way of a writ. That's it. Simple as that. The case law, principle, and your statute. Sorry, you start off with your statute, case law, principle. Because this is just like an essay question. You see the first one, 7 marks, the second one, 6 marks, 7, 8, 9, 10, 13 marks already. Okay, 13 marks, this thing you can do properly, you get 9 or maybe 9, 8.5 over 13. And your question C, you just need to collect. Question C is 12 marks. Even you get 6 marks, you pass this question. See, this type of question, you must do. You must do because you can collect your marks. 7A, 7B, you definitely can do. The only thing, even C is straightforward. C is straightforward. Nothing, you cannot tell that you cannot do C. It was very straightforward. Nothing, what do you call it? There's nothing like hidden or nothing that they are trying to trick you or it's quite a straightforward question. So this kind of question you have to do compared to the earlier question which we did. All right. So if you look at this question sub C, Ramla comments. On the day fixed for trial, Ramla and his solicitor, Ramla commenced a writ action against Fatima at the High Court in Shah Alam. So Ramla versus Fatima at High Court in Shah Alam. In the same action, Fatima counterclaim against Ramla. Same situation like earlier, the Alex question. Okay. At the last case management, the High Court directed parties to file their respective bundle of documents for both the main claim and the counterclaim a week before the trial. Correct? That means the court has given you direction to file your bundles for both the main claim and the counterclaim 1 week before the trial. On the day fixed for trial, Ramla and his solicitor did not attend court. Okay, Ramla and his solicitor did not attend court. Ramla's solicitor, however, faxed a copy of the medical certificate to the court. Ramla's solicitor did not file the bundle of documents as directed on the other hand, Fatima and her solicitor were present in court. Fatima's solicitor has filed the bundle of documents as directed by the court. So you can see Ramla's solicitor did not file the bundle of documents as directed, but on the other hand, Fatima and her solicitor were present in court. Fatima's solicitor has filed the bundle of documents as directed by the court. Since both Ramla and his solicitors are in court, Fatima's solicitor are not in court, Fatima's solicitor applied to the court that Ramla's claim to be dismissed and Fatima's counterclaim to be allowed. You are to provide your opinion on Fatima's solicitor's application. What are you going to do? So now you will have, okay, what is your answer? Which one will you choose? Which one will you choose? Which provision will you choose? What is Fatima's lawyer's application? Since both Ramla and his solicitor are not in court, Fatima's solicitor applied to the court that Ramla's claim be dismissed and Fatima's counterclaim to be allowed. Right? That's the application. Someone has given order 35, 34, rule 6, 35, rule 1, sub 2, did not attend court, 35, rule 1, sub 2, okay? What do you think? What do you think? There are two answers to this. There are two answers for this. First thing, you must answer 34. You must tell the court that, correct, you did not file the bundle. I've given you direction to file the bundle of thing, but you never file the bundle, right? You never file my bundle means you never follow my directive. If you never follow my directive, pursuant to, because if you look at that, this is a mixed question. You go to order 34, rule 2, subsection 3, the court having given direction under rule 2 sub 2 or rule 3 may either on its own motion or upon the application of any party, if any default in complying with such direction, dismiss such action or proceeding, or strike out the defense or counterclaim, or enter judgment or make any such order as it thinks fit. Correct? That's the first thing you must address. I know now the action is in court. I understand that. But first thing you need to tell, your failure to comply with your pre-trial direction. There's a directive that's already been given. 1 minute. There's already a direction that is given and you have failed to comply with that direction. Correct? So this is the first part you have to answer. Never comply with the PTCM direction. This is what the court can do. After that, then only you go into the application. Since both Ramla and his solicitor are not in court, Fatima's solicitor apply to the court that Ramla's claim be dismissed and Fatima's counterclaim can be allowed. Then only you go under your order 35 to tell that what happened. But you must add on to this issue of medical certificate. Correct? There's a medical certificate that is produced. So you need to tell there is a medical certificate that has been produced on the issue on this issue. However, end of the day, it is still on the discretion of the court. Same answer like this now. Only addition, you need to address 34 rule 1. If you want to put like 34 rule 1 sub 3, if you want to put 34 rule 1 sub 3, then you have to address 34 rule 2 sub 3. Okay, most of you get it. Most of you got it right. Okay, so this is same like how we have done it. You have to add on the thing because you never comply. You never comply, then you come to court. On top of that, you come to court, you are not present, right? On the day fixed for trial, Ramla and solicitor did not attend court. You are the plaintiff, you never attend court, you never comply. So there are two issues. So if I'm the defendant solicitor, I have two issues to tell. I will tell pre-trial non-comply, pre-trial direction not comply, never come to court, they are the plaintiff, it's their case, they have to prove. So now invoke your power under 35 to tell that what, because what I'm asking now, enter judgment, so correct? Apply to the court that Ramla's claim be dismissed and Fatima's counterclaim to be allowed. So since it's a 12 marks, once again, the whole discussion that we have done earlier. The whole discussion that we have done earlier, 34 plus your 35. Can I set aside, how to set aside? So that part, you need to somehow know how to write since you can see it is repetitive. Can? Okay. You see, it is not, where is it? Not attend, okay. It is not failure to attend PTCM, They did attend PTCM, they never comply with the directive. So you cannot take 34 rule 6. Someone gave an answer 34 rule 6. 34 rule 6 is failure. Not failure to attend PTCM, it is failure to comply with the direction that is given in PTCM. Okay, it's two different things. Take note on that. Okay, October it's done, October 2014. The next question will be November 2015, question 2A, November 2015. Okay, we look at November 2015, 2A and 2C. Remember, just now I was telling you all this question. This one, essay question. Okay, November 2015, question 2A, there are consequences for a party if it fails to comply with an order issued by the court at the pre-trial case management. Discuss. Same like earlier. So, same thing, 34 rule 1 sub 3, 34 rule 2 sub 3. If I don't comply with the pre-trial direction, this is what the court can do. I don't even have a case law on this. This answer is here. There are consequences. What is the consequence? I can enter judgment, I can dismiss, I can strike out, I can do anything. That is your consequence. 34 rule 2 sub 3. Answer question. Just answer the question. You might be thinking, why the answer is so short? That's all for you to write. If you want to add on for cases, yes, you can add on, no problem. I don't want to add on because I think nothing much to add on here. So if you have cases you want to add on, please go ahead and add on. But I will not add on. I'll just stop because I've answered the question. Basically, I've answered the question. There are consequences for a party if it fails to comply with an order issued by the court at the pre-trial case management. Discuss. So first thing, I explain my general rule, like what I told you, 34 rule 1 sub 1, then sub 3. Then I go to 34 rule 2 sub 3. I explain the point. Finish. I'm done with my answer. Okay. Sub C, the judge may, if it thinks it is expedient in the interest of justice, adjourn a trial for such time and upon such term, if any, as he thinks fit. So this question is basically on your adjournment. So it's like a complete discussion on your adjournment issue. So you have to state adjournment is basically in the discretion of the judge in Sas Berhad versus Ayan Molek. You must use your practice direction 1/2019. Then you must go on to your what do you call that? The additional factors that court can consider. You may want to add 1 or 2 cases. Like I will add Go Pak Hong, Dinah Chu, okay, and whether, okay, because this question here is discussed, correct? Whether appellate court can interfere with the decision of the lower court to grant or not to grant adjournment. MGG Pillay versus Vincent. Those are the case that I use. If you don't want to follow that case, no problem. You can just use the case because it's 10 marks. It's open-ended question. I'm just going to discuss. But if you think I don't want to use that argument, I don't want to use the appellate court argument, no problem. At least you must have the basic of an adjournment. Put in your order 35, okay, and then you go on with it. Okay, up to you how you want to answer the question. It's your wish. Just that don't keluar tajuk. That's all. But you see, here 7 down 10, correct? 17 marks here. Your sub D is also straightforward. It's on your order 24, rule 7A, on your discovery. Okay, order 24, rule 7A. But you need to be very clear. There are 2 issues there. One, party to a pending action and future action. So you must explain rule 7A1, rule 7A2, and then the whole procedure for discovery. You don't have to go. You see, when you get this kind of question, myself, I will not touch the Norwich Pharmacal rule, or some of you, yes, you always touch. I will not touch. I just answer the question based on the statute. So I'll go through on the law because now it's already codified. Why should I answer the old law? No need, what? Everything is here. That's what I will do. But if you are not that type, you are the type who want to go one by one, also can. But see what they're asking. So you don't have to go through order 24, rule 7, order 24, rule 1, order 24, rule 2, rule 3, don't need. They already ask you against a person who is not a party pending an action. This is stranger, go into 7A. Please answer the question. All right. And the last one is question August 2016, question 3C. Same like our earlier question. Under what circumstances will a court make an order that an OS procedure to be continued as if the course of matter had begun by a writ, and describe the procedure that is involved? Okay. Thus now, they never give you clearly like this, correct? They say proceeding irregularly, comments, blah, blah, blah. Here, straightforward. What circumstances will make a court, will a court make an order that an OS procedure to be continued as if the course of matter had begun by a writ, and describe the procedure? Straightforward. Same thing when there's a dispute as to facts, the court will the court will direct the OS to be converted to a writ. Order 28, rule 8. Same answer. Chiao Chio Poon versus Abdul Johari, Ting Ling Q versus Ironworks. You have other cases. These are just the 2 cases that I always remember for this kind of question. Plaintiff's claim is dismissed. Can we apply to file afresh? Okay, you see, this question is open-ended. You need to tell me plaintiff's claim dismissed based on the merits or only on technical ground. Only based on that, I can give you an answer whether we should file afresh or we must appeal. Just because just now I gave you the distinction, right? Okay, if technical ground, that means you go back again to your whatever order 35 and the thing. So you file afresh is still within limitation period. You understand? You understand that part? This is on the dismissal, not on judgment, and there are 2 different things to it. Okay. If it's dismissed, you also have another question. Just I never do the question with you all now. There are also questions where they have given you the plaintiff's case is dismissed upon hearing the full action. Okay, upon hearing the full action, the case is dismissed. In that kind of situation, please don't go and put refile. It should be because they have listened to the whole thing. One more thing, I'm not not sure whether you all know. Your summary judgment, because already I addressed this issue, let me just address. Summary judgment, if one party present and then you obtain a summary judgment, that judgment can be set aside. However, if two party is present and you are plaintiff has obtained a summary judgment, the party who is dissatisfied with the summary judgment under order 14 must appeal. Okay? Must appeal. How I know? Open your order 14, rule 11. It's all stated there. Please don't make a mistake with this. Huh? All right? Please don't make a mistake with this. You need to work. Okay? Can? Okay, my suggestion to you all, for the questions that we have done today, it's most of the time this question is examinable. If you look at it, you will know. You can even take the recent papers and see your 2018, 2019, you will have this kind of question. But of course, they have added a little bit. Judgment in default, they have added this and that over there. Okay, I will suggest, please write down a full answer. Keep a full answer for this kind of question so that you can use it for you can use it for the other question. One of prosecution, for me, I will not do it. Okay, because for me, it's already codified. I understand it's in your syllabus. Even in my own class, my students, I told them, no, I'm not going to do it because it's already there. If you look at Syed Omar's case already explains under Order 34, where now is for the court to move litigation, no more to the parties. So I will skip that chapter. And if you do your own, research for the past 5 years or 10 years, they don't have this thing. Everything is under Order 34. Okay? Okay? All right. I will send you all the answer later on once I'm done with this. Later on, maybe about 8, 9 o'clock, I'll send you all the answer. Other than that, any question? Anything? Okay, I take it as no question. So I wish you all the best for the exam. Make sure you read the question properly. Thank you so much. Read the question properly, answer correctly, answer on point. All right? Okay? Okay, thank you.